Today we're going to go through patent fundamentals, and additionally I have handed out the first of 2 homework assignments for the course. In order to learn to write patent claims, the task that handout's right there. The task is to do this all on your own. This is not a group project. This is not a project that should have you going through past files of this course to find out what somebody else did or whatever else. The challenge is to use your own mind to figure out how best to write the patent claims, the invention definitions. And it is really only through that process that you can learn better how to define inventions. The answers to this course, if correctly written down because you copied them from something else or learned about it from somebody else, give you no value in the process. So I believe in my past years that everyone has done that, and I would just suggest that in this course you continue to do that, as everybody else has. It's your own development of your own analytical processes that are really the focus of the course. And for that, you really need to do this by yourself, not asking your roommate or your neighbor or whatever else how it is that they went about defining this the novel break in our homework assignment. So that's what I would ask for you to do, and I think you will find it challenging. The answers that I would like on this homework are generally very brief. If you take more than a page to give me your answers, you've done way too much. Some of the best scores have had maybe 20 or 30 words total in their homework that they turn in. The goal is to define this leaf rake in as abbreviated a fashion, as clear a fashion as you can, provided that that definition doesn't read on the prior art that's shown in the homework. And we'll have more examples as we go along, more in the next lecture than this one, but that's really the goal. This course is not looking for good English, it's not looking for correct spelling, it's looking for correct analysis. That's what really matters. It doesn't matter whether you have a pretty typed homework or whether you scrawl it the morning that it's due on the backside of an envelope and turn that in with your name. That doesn't make any difference. What matters is the analysis that you do on your own, figuring out how to best define this leaf rake invention. So that's pretty much the criteria for the homework, and it's the criteria for the rest of this course as well. We have a second homework, not too burdensome, of course, but we have a second homework that will be unique to each of you. So it will be very hard to work as a team because it's just yours, and you will do your response, and however you best do that is up to you. And in that homework as well, it's supposed to be all your own work, not anybody else's. The final exam and the study for the final exam, you're certainly welcome to have group study if you want, and go back and forth, testing yourself as to what's on the handouts and trying to make sure you each know whatever it is that I put in the handouts. So there you go. Everything but the study for the final exam is supposed to be your own solitary work, and you're not to try to get prior materials from my prior teaching of this course to use as an aid in getting what you think is the right answer, because that does nothing for the development of your analytical skills, which is the focus of the course. Okay, starting with patent application procedures. The first thing we're going to talk about is provisional patent applications. Provisional patent applications are a temporary way to get a filing date for your patent. that does not have the same full requirements that a regular patent application has. It does require a specification or a description of the invention of some sort and a drawing, if appropriate for the invention. A provisional patent application is automatically abandoned 1 year from its filing with the presumption that within that 1 year you would file a regular patent application that would be done according to all of the requirements for a patent application. And it would then get the benefit of that provisional application if you filed it within that 1 year period of its pendency. When you consider how long a patent lasts, you don't take into account the time period for any provisional patent applications that may be pending or may have been filed. Its term for a patent is measured from the filing date of the regular patent application, and it is normally 20 years for utility and plant patents. It is not measured from the date of the provisional application. So one of the strategies, if you want your patent term to last until a later date, is to file a provisional patent application written in the same fashion as you would write a regular patent application. You file it, and then 1 day less than a year later, you file that very same application again as a regular patent application, claiming priority from the provisional application, and that will then start your term, your 20-year term, running from that later filing date, which makes your patent last a year longer than if you had filed a regular patent application in the first instance. Whether it's worth the extra hassle and extra filing fee for a provisional to worry about the 1 year term 20 years later that you might extend it into is a question you have to address for each case, and whether or not there might be some intervening infringer that you want to have your patent already issued is something else that you would consider, because if you file your regular patent application earlier, it's likely to be examined earlier and issued earlier, and oftentimes getting an issued patent is very important, particularly for small startup companies that are looking for funding and investors. You do not have to have any patent claim in a provisional patent application. You don't have to have an oath of the inventor or applicant, but you do need to name who the inventors are. It is inexpensive to file, but if it's not carefully prepared, what you put in a provisional may end up compromising your rights in your regularly, properly prepared application, because once you fully prepare a patent application, you will have to write patent claims that will be carefully thought through, and when you write those patent claims, you then need to know exactly what has to be put in the patent application to support those patent claims. If you just file a provisional application and you don't think about the patent claims because they're not required, you might not describe the invention in the same fashion as you would if you had had an invention definition already figured out that you're going to stick with. So people get into trouble with provisional applications, but they're very handy if you have some imminent deadline and you need to file a patent application very quickly, and you don't have time to write a thorough, careful, regular patent application. Things that can be patented. The statute says, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore, subject to the conditions and requirements of the patent laws. Okay, this does not include ideas themselves. If you discover that E equals mc squared, and nobody had figured that out before, you can't get a patent on that discovery of that relationship. That's a fundamental idea. It isn't related to any useful process, machine, manufacture, or composition of matter. or any new and useful improvement thereof. It's just an understanding of a property of nature that hadn't before been discovered. That's not something you can get a patent on. On the other hand, if you discovered E equals mc squared, it may be able to give you the power to invent some machine, a nuclear reactor, for example, that nobody else would have thought to make. And that new reactor that you've invented that nobody else thought to make because they didn't know that relationship might give you a patent that would be very valuable. So when you come up with a new idea, you have to think about how that idea can be applied to make a machine, to make a useful process, or to make a composition of matter, and then seek patent protection on those applications that actually benefit society. Things that are the subject of a utility patent include architectural designs for buildings. Genetically engineered mice can be patented. You can patent an element in the periodic table if you invent it with your nuclear accelerator. It's some new element. As to methods of doing business, in some sense, they fall within the description because it is a process as to how you do business, but it is not yet clear as to what extent it may be patentable. The U.S. Supreme Court has recently decided in the case of Bilski versus Capos that a method to hedge commodities is not patentable. It's sort of a financial transaction thing. And it determined that it was not patentable. Our firm obtained a patent on a credit card incentive system. And that was found to be patentable, patent issued, and it was enforced in courts after challenge. So the line of what exactly is a method of doing business and what is not is in flux. So whenever you have that issue, you'll need to see what the latest law is on that. Now we talk a lot about prior art. Prior art is the term used to describe all things done before that are entitled to be used as evidence against a claim of patentability of another, usually later invention. Now, this definition depends upon the laws of the jurisdiction that's applicable. What is prior art in the United States is different than what is prior art in Japan, which is different than what is prior art elsewhere. There are some commonalities, and Congress has recently passed a law to move the United States law closer to the rest of the world. And so the differences now are much less significant as they used to be. The U.S. now has a first-to-file or publish system. It's often referred to as a first-to-file system, but in fact, the United States system has a variation that gives you an earlier date for your invention if you published your invention before you filed, provided you filed within a year of that first public disclosure. So in the United States, prior art includes any public disclosure that is both before the filing of the patent application and before any publication by or derived from the inventor, published not more than a year before filing. Most of the rest of the world has a first-to-file system with any earlier public disclosure, normally distinguishing the right to file. Prior art includes any public disclosure prior to filing for the rest of the world, for the most part. So, if you come up with your invention, you run outside and you yell to your neighbors, "Eureka, I have come up with this great invention. This is it." And your neighbors are all listening. you have just lost your right to get patent coverage outside of the United States. You still have the right in the United States to file within a year of that front yard disclosure, and provided you do, you'll be okay in the United States, but you won't be able to get patent coverage outside of the United States if the laws in most of those other countries are applied. More specifically, the new law that was passed takes effect March 16th of 2013. And the public activity is specifically listed that triggers the time period that within a year you have to file your regular application. Printed publication, public use, or on-sale activity, that is before both the application filing and any activity, directly or indirectly, from the inventor that publicly discloses the invention within 1 year before the application filing date, would prevent you from getting your patent. Somebody else files their patent before you do and before you've made it public, then that other person's rights extinguish yours. To the extent that somebody else published earlier and you didn't file or publish until later, then you do not have the rights to your invention. Now, the standard before March 16th, 2013 was a combination of the first to invent and any publication or commercial use or offer for sale more than a year before filing. And the first to invent was sometimes difficult to establish, and it was very difficult for a person who sees a patent to know whether that was a valid patent or not, because you're not given information as to when that inventor made his invention, so you can't test it for validity. So the new system that takes effect March 16th eliminates that ambiguity. Now, in this course, our final examination will not address any legal standards that do not continue in effect as of March 16, 2013. So we will be proceeding as though the law is as it will be as of March 16, 2013. You don't really have to know what the old law is or where we're headed, because your future is ahead of you. You don't really have to delve into the first to invent standard. In competition between two simultaneous independent inventors, the first to either file or publish prevails, unless the publication is more than a year before the filing, in which event the case is not patentable either. A person who derives an invention entirely from another is not entitled to file a patent application naming himself as an inventor. In the United States, you have to be an inventor to have rights to file a patent application, or you have to obtain rights from the inventor if the inventor has a duty to assign them to you in order to file a patent. You cannot file a patent on something you learned completely from somebody else.
So, another question on the last slide. So basically, if you were to publish your invention and it didn't file within the following year, then you wouldn't be able to patent it.
Nobody could patent it. That's that.
Even you yourself.
That's right.
To add to that, do you have to file a full patent, or can you file a provisional within that year?
A provisional is just fine if the provisional has enough of your invention so they know what it is. That's the purpose of a provisional, because we have these hard deadlines. You file a provisional to get your filing date, and then you make it nice and pretty later.
So in essence, you'd be able to extend the patent 2 years if you took advantage of the publishing and the provisional.
Well, you could delay 2 years by doing that, except for the fact that that first publication before you filed your provisional would extinguish all your foreign rights.
Okay.
And not many people are willing to do that at that stage of the process. But you are exactly right in your analysis. obtain international patent coverage in most foreign countries, you simply have to file your patent application before the invention is publicly disclosed. Neither private use of an invention nor commercial use that doesn't reveal the invention to the public has any impact on the rights to file a patent application in international patents. That is probably also the case in the United States, although that point of law is still unresolved. In my view, that's likely how the law is going to be resolved under the new statute, but that's an area of ambiguity currently.
What if an idea is leaked? Say you don't publicly disclose it, but somehow it gets out.
Somebody in your trust, in violation of their duty to keep it secret, tells the Wall Street Journal and they publish it? That's your hypothetical?
Or somebody hacks into your system.
Okay, a criminal breaks in and gets a copy and puts it on the web. The website, here is this great invention that if it's done illegally or in violation of the duty in most foreign countries, that will not count as prior art. It would have to be done with your authority and not as a criminal act. So that there is a saving provision for that instance. That's a good question. Paris Convention. Because nobody wants to have to file patent applications in huge numbers of countries when they first come up with an idea, virtually every country in the world has signed a treaty that says we will recognize the filing of your patent application in your home country as though it were in our country, provided that within a year you file a patent application in our country. So you have a 1-year period from your U.S. filing date within which to file overseas, foreign countries. And virtually every country in the world has signed that treaty, the Paris Convention. And that basically allows you to put off decisions with regard to international coverage with a single filing, a single patent application in some country, anywhere, that is a signatory to the Paris Convention.
So there's no one, I guess, agency that handles all the international patents.
That's true as an absolute statement. It's just a treaty where the countries will recognize one another under the Paris Convention. If we go to our next slide, however, there's something called the Patent Cooperation Treaty. Not everybody has signed the Patent Cooperation Treaty. All major industrialized countries have, but there are a lot of countries that have not yet signed the Patent Cooperation Treaty. The Patent Cooperation Treaty is a much more comprehensive way to deal with a single patent filing that can be used as your patent application in other countries. And it is routinely used because it is much less expensive and it gives you a much longer time period in order to decide whether you want to file in those foreign countries. It has a single patent application where you designate which countries you want it to apply to, and there is a single search that is done in order to determine whether or not there is relevant prior art that might be applicable to that patent. And the person who files under the Patent Cooperation Treaty can elect which country of a good number of countries it wants to do the search to see if they can find prior art. So that's a process that is used more and more in order to simplify getting coverage in multiple jurisdictions with a single filing.
So just a question on that then, why would you not want to pick all countries?
It's just money.
So you have to pay for each country that you select on this list as far as...
You do for some, for others you do not. You can select the examining authority that's going to do the search, and those There's competition among the countries on price and quality. And so do you want a really high quality search, you might pick Europe. If you want a low cost search that's reasonably good, you might pick Korea to do the searching. You might pick the United States to do the searching if that's your primary market. You want the United States Searching Authority to be up to speed on the technology when they get to the U.S. application later on in the process. So as the details of the Patent Cooperation Treaty, you don't really need to know that for the purposes of this course, but you do need to know that it exists, and it is an option that's frequently taken early on to protect your rights overseas. Instead of the 12-month period that you get under the Paris Convention, the Patent Cooperation Treaty gives you essentially 30 months to decide and come up with lots of money to file in lots of countries. Now, if we look at the particulars of what should be in a patent application, we first have what's called the specification. Generally, you think of the specification as that which describes the patent. It can be understood as encompassing the claims, but oftentimes when you refer to a patent specification, you mean everything except the claims. The specification shall contain a written description of the invention and of the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to which it pertains or with which it is most nearly connected to make and use the same. So you have to have something that enables other people to make your invention from reading the patent. It doesn't have to have all of the details as to what the best source is for the lowest cost components or what the values of the resistors should be in the circuit that you come up with, because that's something any person skilled in the art can figure out on their own if you've otherwise told them how the circuit works. But it does have to have enough so that a person, given the patent specification, who reads it, could actually make the invention and have it work without undue experimentation of his own. The patent application is also supposed to set forth the best mode contemplated by the inventor of carrying out his invention. And the United States patent law requires that you not hold back the really good way to make your invention and disclose an inferior way to make it, so that you can get broad patent claims but not really let people know the best way to use your invention. So you have a duty to disclose your best mode. However, under the new law, best mode challenges are very difficult to make except by the patent office, which rarely makes those challenges. So even though this is the rule, and it is your duty to set forth the best mode, there are barriers to challenging a patent for failure to comply with this particular requirement. Models. It used to be that patent applications were accompanied by models of the invention, but that's no longer required. All that's required is somebody can build the invention without undue experimentation. The patent office still has the power to require submission of models or samples of compositions of matters, but it typically only does so for perpetual motion machines and rare inventions which otherwise radically challenge conventional science. So there are very, very few cases where models have to be submitted. And generally speaking, there is no requirement that you ever have built your invention in order to file for a patent on it. For example, if you've come up with a new way to make a nuclear fusion reactor, you don't have to build a new nuclear fusion reactor in order to file a patent on it. It might cost $500 million to build the thing, and you want to get a patent to get investors to give you the money to build it. So it's never a requirement, unless you have a perpetual motion invention, that you actually make the invention and build it. often advisable, because in the process of making the invention, you often learn things that would be very helpful to better define the invention. And you can then get stronger patents oftentimes if you've made a model, but it's not required. When you file your patent application, that disclosure is fixed at the time of filing. You cannot add new matter to the specification after filing, except by a mechanism of filing a continuation in part application. That's a brand new application. That carries a later filing date for applying prior art as to claims covering the new matter and not the old. So you can actually file a new patent application with a new filing date that has new matter in it, but that new matter isn't going to benefit from your earlier filing date. You can modify your patent claims after filing if the modified claims are supported by the specification. So that's done routinely in a large percentage of cases. You file with a certain set of patent claims and the examiner gives you a rejection. And then you say, oh, well, if I rewrote the claims in a different way, still supported by the disclosure, then that's fine. You can change the claims all you want, provided there's support in the specification for those claims. But you can't add new matter. You may have disclosed the use of tungsten and molybdenum, but you didn't know that cesium would work equally well. And so you're out of luck if you want a patent claim that covers cesium. You can't just add that and all forgot. You're stuck with what you have, or you have to file a continuation part application where you put in that new matter. And then the claims are looked at individually. Those claims that are supported by the earlier application get the earlier application's filing date for consideration of validity. Those that don't get the later continuation in part application's filing date for considering validity. Patents have to have drawings where necessary for the understanding of the subject matter sought to be patented. Almost all patents have drawings in the mechanical field. Areas where they don't have drawings, sometimes in the chemical field, you can have patents that don't require drawings. But almost all patents have drawings, and almost all inventions are better understood with drawings. And so almost always you would want to use drawings where it's suitable for the particular invention. You can't get an enforceable United States patent if the inventor or the assignee of the patent application knows of material prior art and in bad faith fails to tell the patent office about it. You have a duty in the United States to tell the patent office if you know of prior art that is close to the invention and you purposefully don't tell them in order to sneak something through that should have been done. That's a requirement in the United States. It tends not to be a requirement overseas, but it is a requirement in the United States, and it's one that is oftentimes raised as a defense when somebody tries to assert their patent against somebody else. Looking at patent claims, they are the major factor in determining whether a patent is infringed, and an important factor in determining whether a patent is valid. Each claim in a patent is separately considered to determine whether the claim is valid or infringed. So you can have some claims in the patent that are valid, some claims in the patent that are not valid. And the patent is fine as to those claims that are valid. You just ignore the ones that are invalid. And some of those claims might be infringed, and some of the claims might not be infringed. If a claim is valid and infringed, then you can get your injunction. You can get damages for the infringement. If a claim is either invalid or not infringed, then there's no remedy as to that particular claim. But there may be as to other claims in the patent. Inventions are typically claimed as combinations of elements or steps that are each whole. It is the entire combination of elements or steps recited in this claim that needs to be novel, regardless of whether any or all of the individual elements or steps are whole. This is difficult for people to grasp right at the beginning, but in a sense, every invention ever made is a combination of old inventions, old things that people knew about. Even the patent on the new element in the periodic table is a combination of neutrons, protons, and electrons, all of which are old, just rearranged in a new way. So it is really not significant that each of the different elements that are recited in defining the invention are old. What's significant is whether the entire combination is old. If the entire combination is not old, then you have an argument for patentability. Patents all have abstracts. Abstracts are used primarily as a searching aid, and initially they were not to be used for interpreting the patent, but now abstracts sometimes are used. And so you take care as to what your abstract says. After filing an initial application, more applications with identical specifications can be filed, and if they're filed while the initial application is pending and refer to the initial application, they will be treated as though filed on the initial application date. You can actually end up with a lot of patents from a single patent filing by filing continuation applications. If those continuation applications have inventions that are different but still supported by the application that are being claimed in the original application, then you call them divisionals. You divide an invention off from other inventions that are in the original case. If they're claiming the same thing, then they're generally referred to as continuations. The patent office can require an initial application to be separated into 2 or more applications if they believe that 2 or more inventions are to be claimed. And they routinely do that because they get paid for each invention that they have to search. And so when they look at your patent application, they may say, this looks like 5 patents that you should get on this, so give me 5 times the filing fee to examine all 5 inventions, and you can do that. And it's hard to argue with them sometimes that, in fact, there really should just be one examination, because they will argue that each claim is coming at it differently, and they would like to get more money and have more time to analyze each invention. Secrecy. Most patent applications are published within 18 months of their effective filing date. If the United States applicant requests secrecy, and when filing states that no foreign cases will be filed, an application can remain secret until patented. Only the United States has this provision. Other countries, to the extent you file in those, are going to publish the application 18 months from filing. The United States allows you to keep it secret as long as you're not going to file in a foreign jurisdiction. And the rationale is, if you're going to file in a foreign jurisdiction, you might as well publish in the U.S. because the foreign jurisdiction is going to publish it at the same time. So you're not entitled to keep it secret. But if you elect not to get foreign coverage and just get coverage in the U.S., then you can keep it secret until patented. And if it doesn't get patented, then nobody will ever find out about the invention. That happens on occasion. U.S. design patents are always secret until patented. And if national security is implicated, if you have a new way to make a nuclear bomb, then your application will be placed on hold until security is no longer an issue, which may be never. If security is on your application, if it's classified, then your patent will be maintained secret, and the 20-year period will run out, and you will not get a patent.
So in that case, can you not defend if somebody else will try to use your patent? I mean, I don't even know if that's a big deal.
If national secrecy is involved and somebody else is using it, if that other person's use is public, then it's no longer a secret. You can get the secrecy order lifted. But if that other use is itself secret, there's nothing you can do about that. You will not get a patent, and they'll be able to use it in secret. and the government will say, we don't want it to be known for our adversaries to have that information. And so you won't get a patent if that process takes 20 years. In the United States, utility and plant patents expire after 20 years. Sometimes more. If there's been delays in the patent office, they'll give you a little extra time. If it's due to the patent office's delay. And at 20 years is measured from the regular U.S. filing date. One of the things in the United States is that every so often you're required to pay maintenance fees to keep the patent in force. In the United States, there are 3 times you have to pay them. One at 3.5 years after issuance, one at 7.5 years, and one at 11.5 years after the grant of your patent. Earlier filed provisional application filings do not affect the expiration date. In the United States, design patents expire 14 years from the date of the grant and require no maintenance fees. You'll notice that these have some bold-faced words in them. That's a hint about whether they might be on the final exam. I'm not going to say it is or isn't, but that's a hint. Foreign patent terms. Most foreign patents expire 15 to 20 years from their effective filing dates. Most foreign countries require annual payments of maintenance fees to maintain their patents in force. Like in the United States, every 4 years you pay maintenance fees. Most all foreign countries require annual payments to maintain their patents. And those payments get larger and larger over time. Now this is a really critical part, and for whatever reason it's right at the end of the lecture, so some people are sort of losing touch. And they don't remember this on the final exam. But it is a really important thing. Patents are assessed as to whether or not they should be issued or not, as to whether or not the inventions being claimed would have been obvious to people of ordinary skill in the art. An invention that would have been obvious to a person of ordinary skill is not patentable. Inventions that would not have been obvious to a person of ordinary skill may well be patentable. And the standard of obviousness is measured as of the filing date of the claimed invention, because we're first to file, or if there's an earlier publication within a year, it actually turns out that it would be measured as to the date of that earlier publication in the United States. So that's the standard for patentability. Now, how do you determine whether something would be obvious to a person of ordinary skill in the art? This person of ordinary skill in the art is somewhat of a mythical character. We don't know who a person of ordinary skill in the art is, but the courts will define that person and tell the jury who that person is, and the jury will figure out that if there are factual questions, they will figure out then whether or not the invention was obvious, and then make a determination whether the invention should have been patented or whether it was a mistake to have patented it. One of the interesting things in the United States law, and I think pretty much the law throughout the world, is that it doesn't really matter how you come up with the idea. The language of the statute says, awkwardly, patentability shall not be negative by the manner in which the invention is made. So if you come up with an invention because you were really clever, you figured it out, great, you get a patent. If you come up with an invention, even though you're dumb and stupid and not clever, but because you tried all the 100,000 variations and you finally found the one that worked, great, you get a patent. Nothing to do with your cleverness. If you were an idiot, you did the exactly wrong thing that nobody would have done because you didn't know what you were doing, and you stumbled upon the invention, great, you get a patent. Doesn't matter. Makes no difference how it is you come up with the idea. If the invention is unobvious, that defines whether you get your patent. It has nothing to do with how you got there. determine this mythical person's understanding as to whether or not the invention was obvious, the courts have turned to what they refer to as secondary considerations. And basically, this is circumstantial evidence as to whether or not the invention would have been obvious. Nobody knows as an absolute whether something would have been obvious or not. People have opinions that would have been or wouldn't have been based upon their own personal experience. But the courts look at secondary considerations to determine whether or not an invention was obvious. First one to consider, and there are more beyond this list, but these are lists of conventionally considered secondary considerations. Long-felt need. If people have been needing this invention, a cure for AIDS, for example, somebody comes up with the idea of how to cure AIDS and it works, I can guarantee you that will be an unobvious invention. Nobody's going to be able to say that people knew how to cure AIDS, they just didn't want to do it for 20 years. So the long-felt need is a circumstantial evidence that, in fact, something is patentable. And I suppose the reverse is true as well. If there hasn't been a long-felt need, all of a sudden the need arises, and a day later 10 people come up with the solution, then that probably shouldn't be patented. Another thing is the availability of resources to make the invention earlier. If this cure for AIDS or whatever the solution might be for whatever problem arose uses resources that have been around for 20 years, that suggests that it really is patentable. If the resources needed to cure AIDS were just invented by somebody else, even though they didn't appreciate the cure for AIDS, then it's more questionable as to whether or not the AIDS cure is patentable to the person who did that, because it's only because the resources became available that he had that idea, and maybe 20 other people or 100 other people came up with the same idea at the same time that they saw that new resource appear. So that would be the kind of thing to think about on the circumstantial evidence of obviousness. Imitation or prompt adoption by others after seeing the invention, particularly when it's accompanied by initially discrediting the invention, is a very strong indicator, circumstantially, that the invention was not obvious. Where you have cost reduction or improved safety or effectiveness, those both are indicators that it is patentable, because most companies want to reduce cost and improve safety. And if they didn't do it for a long period of time, and the invention comes along and allows for that cost reduction, that suggests it was an unobvious invention. Industry recognition and awards are also used. Commercial success that's not due to advertising can be a secondary consideration indicating obviousness. So these are important things to remember, particularly at final exam time. And if you have any questions,